Good evening to all of you. Welcome to my Jurisprudence class number 13 I believe. Today we are going to discuss the binding authority of the customary law. First of all, already we discussed the binding authority of the legislation, the president, and now we have come to the so-called customary law. So the first concept we have to know is custom is to society. Custom is to society, whereas law is to the entire state. So because it is related to other aspects also. Please remember, custom is an important and a primitive or natural or aboriginal source of law. It is the oldest source of law. Please remember, customs arise out of principles of natural justice and also public utility. So this you have to remember. Then definitely custom. If I will start with some examples. For example, according to Hindu Marriage Act Section 5, Sapinda or Sagotra marriage is not allowed. That means, as per Section 5, you cannot marry your sister's daughter. But how many people, మనలో ఎంతమంది మేనకోడలు చేసుకోవట్లా, అక్క కూతురు ఎంతమంది చేసుకోవట్లా? How you are going to do that? Because of the customary law. So this customary law is allowed as per Section 13 of the Indian Evidence Act. It says facts relevant to the existence of any custom or right. Custom or right, they are admissible. And according to Section 48 of the Indian Evidence Act, yes, it tells about the opinion as to the existence of any right or custom. A right like easementary right, custom. So going to spread. For example, if the people are you have in the habit of going to certain well and fetch water, yes, that is a custom. So this can be actually made admissible with the use of Section 48 of the Indian Evidence Act. Of course, that is the present stage. So because they are binding, now they have taken the shape of the law. That you have to know. And second, please remember, the customary law, it has got the stability and also certainty. So valid custom, you have to know the principles of the valid custom. So I will tell you the conditions later. So first of all, it has got stability and certainty also, just like our marriages of Hindu customs. Then custom, it has got a relation with religion because it is related with the principles of religion. Previously, even I told you in the sociological school and also the philosophical school, in these two schools, please remember, the religion taught us good principles. Religion dominated the so-called society. In the primitive days, religion taught us the good principles for the people. So please remember, therefore, custom is as old as the religion also. And please remember, so to give the binding force, what are the conditions? Number one, how can you say that the custom has got the binding authority? Point number one, custom is the embodiment of the principles or aggregate of the principles which have commenced from the from the notional principles. So notion, we do like this. Second point is existence of an established usage. So already people are following, people are using the same custom. So on the basis of rational expectation of its continuance in future. So the old people, just like our Samitalu, so the old people, they have formulated the so-called customs for the benefit of the future generation, for the existence of the future generation. So for the continuation to the future generation. So this is useful. వాళ్ళు ఎంత ఆలోచించి ఫ్యూచర్లో పనికొస్తుందని చేసినవే కస్టమ్స్. Sometimes a large number of people may follow or may observe a particular custom and it goes after some time it takes the course of law, just like as stated in Section 13 or 48 of the Indian Evidence Act. And please remember, custom. The people have got the popular notion that custom has its force in the interest of the society, in the best interest of society or public policy. Then custom is useful to lawgivers and also codifiers, because you may be knowing Lord Macaulay, when he wanted to codify the Indian Penal Code, the English people, for example, they have moved the entire country and they have discussed with the people and they have learnt about the customs of the common of the people, and then only they have taken the customs into the shape of law also, customary law. So, but anyway, the basic point is custom in the society is to, whereas law is to the state, right? So, in the case of Baba Narayan versus Sabusa, 1941, so it was held that to accept the custom in India, so the requirement of long usage from the time immemorial, it is essential to say that it is a custom. Of course, people like me, if they ask that, come on, what is this custom? That is, walking 7 steps is an essential step of the marriage. Suppose I don't accept. I want to know as to who is the person who has framed this custom. Can you get it? It's not possible. So, for the past so many years, it has been in practice. If it is proved, then it is taken as a custom. And an important case, this is South African case. G. Shekhar versus Geeta and others, 2009. So actually, there it is a patriarchal society. So it is significant note that the Southern African Constitutional Court, in the case of BHE Bay and others versus the magistrate Kaelisha is the name, and others, 1927, it was held that the principle of matriarchal or the actual matriarchal society, it is central to the customary existence of the area. So there they said that it should be a patriarchal society. We started from matriarchal society, then we switched on to patriarchal. Now we are also accepting the same. So like that, the customs will be accepted and they will codified, and normally some of the customs, some of the good customs will take the shape of law. Then what about the bad customs? Don't be under the wrong impression that customs are always good to the society. For example, మీకు తెలుగులో చెప్తాను, చీరాల్లో ఈ ఎరుక క్రిమినల్స్ ఉంటారు కదా, క్రిమినల్స్లో వాళ్ళకి దొంగతనాలు జరిగినప్పుడు తగాదాలు వస్తాయి, ఒకటి ఎక్కువ ప్రాపర్టీ తీసుకున్నాడు. ఆ టైంలో అతన్ని పలుగుని ఆయిల్లో పెట్టి మామూలుగా హీట్ చేసి ఆ పలుగుని పట్టుకుని వాడికి కాలకపోతే వాడు చాలా మంచివాడు, ఏం చేయలేదంటారు. ఇట్స్ ఎ కస్టమ్ in the prevalent in the so-called SC/ST colony in that Stotapuram colony. Will you accept it? So this custom is not accepted. Similarly, sati sahaganam, this is also a custom. So husband పోయిన తర్వాత భార్య ఉండి ఇంకేం చేయాలి, బతికి ఏం చేయాలి? So she has to lead the isolated life. She can't. Better to die. So she will jump onto the pyre of the deceased person and dies. So this is also a custom. Do you want to accept the same? No. Bad customs will never be accepted. That's why there should be public utility. There should be public policy. It is in the interest of the society that customs are made. Therefore, customary law is accepted. So friends, this is relating to the customs. I have told you 2 case laws. So please remember them. Whenever you get a question, you can easily answer regarding the customs and customary law. With this, I am concluding. Thank you very much.